Welcome to the Institute of Advanced Legal Studies, part of the School of Advanced Study, University of London. Tonight's event, Windrush in the Law. We'll be hearing from four of our panelists. I'm going to take you through their biographies in a minute. First and foremost, this event is a collaborative event between the Institute of Advanced Legal Studies and the Institute of Historical Research, who are based at Senate House and Senate House Library. So I just wanted to acknowledge Dr. Juanita Cox and her role in, getting this event together and finding the speakers, etc. And also to Argala Rublat, who's a librarian at Senate House Library. There is a really fantastic exhibition at Senate House Library called In the Grip of Change, which is all about the journey to independence, Caribbean and Black British Caribbean history as well. So if you have a chance at some point, I don't know when it's on tour, it's at the end of March. End of March. Really worth coming up for that fantastic exhibition. So I'm just going to go in with a few house rules. There is no planned fire alarms. If anything happens, you just exit through these doors and then turn left the way you came in. Toilets are back through any of the double doors and turn to your right, and then they're on your left. There's also no toilets on the next floor up or down. And that's everything in terms of logistics. So and our networking event is taking place on this floor, and then I'll direct you there when we're ready for that in our conference, which is the little way through the double doors. So this event, Windrush in the Law. So just to give you some context and to introduce you for our panelists as well. So what we're going to do is hear from each of our panelists for about 15 minutes. We also, I'll tell you what I'll do in the introduction. Roadmap now. Okay, so with successive restrictions applied to immigration laws, exploration of hostile environment immigration policies, thousands of undocumented people were denied their legal rights to British citizenship. Many of those affected were part of the Windrush generation, Caribbean foreign migrants who travelled to the UK between the end of the Second World War and the 1970s. Despite their entitlement to live in the UK, many lost their jobs and access to public services and benefits. Some were even detained or deported. These injustices came to be known as the Windrush Scandal, which was first publicly reported in 2017. In 2018, the UK government acknowledged the scandal, committed to righting the wrongs and compensate those harmed by it. Lawyers and law firms have since worked on behalf of those affected by the scandal to support their claims to legal rights. The panel discussion will examine the history of the Windrush Scandal in the Caribbean and transnational context. They will explore changing immigration and nationality legislation and how lawyers have worked on behalf of the Windrush Scandal victims to establish their legal claims. As the first of 30 recommendations in the Wendy Williams Windrush Lessons Learned Review talks about the harm done to members of the African Caribbean community, the panelists will reflect on what can be done to repair the damage. Then you will also receive the document, the Windrush Act briefing document, produced by the Windrush Defenders Legal CIC by Anthony Brown, one of our panelists. And so I'll be talking more about that as well. So, to introduce our panelists. So first we're going to hear from Devyani Prabhat. She's a professor of law at the University of Bristol with legal practice experience in constitutional law. She researches, supervises and teaches public law, migration, citizenship, constitutional rights from a socio-legal and comparative perspective. Professor Prabhat has written and edited a number of books. Her monograph, Unleashing the Force of Law, Legal Mobilization, National Security, Basic Freedoms, won the Burke's Prize for Outstanding Legal Scholarship. And currently she's engaged in comparing how different empires dealt with movement and legal status of people with their realms and manifestations of those measures. Then we'll be hearing from Grace Brown, Joint Head of Garden Court Chambers. She's an immigration expert and human rights expert, with particular strength in cases regarding deportation, including those challenging actions brought against Windrush Muslims. She represents vulnerable children and their families in a range of matters throughout the courts and tribunals. She commenced practice in 1995, inspired by the desire to promote the rights of the underprivileged and disadvantaged, and quickly established herself as a well-respected and pleasing human rights and immigration barrister. She is appointed to the Equality and Human Rights Commission's preferred panel of counsel and was awarded the 2021 BSN Lawyer of the Year in the Chambers category at the UK Diversity Legal Awards. And after Grace, we'll be hearing from Anthony Brown, co-founder of Windrush Defenders Legal, CIC, and chairman of Preston Windrush Generation and Descendants UK. He's a member of the Home Office's Windrush Stakeholder Advisory Group and a member of Windrush National Organisation. Windrush Defenders Legal conducts pro bono weekly surgeries to assist victims of the Windrush Scandal to apply for documentation to confirm their legal status and then to apply for compensation. WD Legal is campaigning for law reform to protect future generations with legislation in a Windrush Act that places a legal duty on public bodies to tackle the race disparities exposed by the government's Race Disparity Audit 2017. The Act would also establish a Commonwealth Community Cohesion Fund. Anthony faced the threat of deportation in 1983 when he fell foul of the 1971 Immigration Act for living outside the UK for more than 2 years. Anthony is also joined by his sons, George and Lewis, who will also be taking part in Anthony's presentation. And then finally, we are discussing this evening is Professor Audrey Macklin, Professor of Law and Chair in Human Rights at the University of Toronto Faculty of Law. From 2017 to 2023, she was the Director of the Centre for Criminology and Social Legal Studies. She teaches, researches and writes in the area of migration and citizenship law, business and human rights and administrative law. She is co-author of The Governance Gap, Extracted Industry, Human Rights and the Home State Advantage, the Canadian text Immigration and Refugee Law, Cases, Mitigating and Commentary, as well as dozens of published journal articles and book chapters. Professor Macklin frequently comments in Canadian and international print, radio and television media. She has also represented public interest interveners before all levels of court in Canada from 1994 to 1996. She was a member of Canada's Immigration and Refugee Board. So I think you'll agree we've got a really wonderful lineup here. Expertise. We're going to learn a lot tonight, I'm sure. And you'll also have a chance to part in the Q&A afterwards. We ask you to engage once we've heard from all our students. So I'm going to hand over now to Jen Yarman.
Thank you very much, Marilyn, for those amazing introductions. And it's such a pleasure to be here in this fantastic panel with people who are actually working on issues and looking at solutions. So I'm very excited about the other speakers on the panel, to be honest. In terms of why I came to this topic, I was editing this book, which is called Citizenship in Times of Turmoil, and looking at the gap between citizenship as an idea in a legal concept and actually what happens in practice, and especially what happens during this question, because is it only during times of emergency that you have issues regarding status like cancellation, or is it kind of a normalized practice to find challenges within it? And that's when I came across Fiona Borden's work, because Fiona was actually investigating issues with mainly older people who had come in and had been working their whole lives in the UK, and suddenly now they're asked for documents by their employers for pension reasons, or they're asked for documents by their landlords. And she was like, people don't have these documents that they're being asked for, And so she started talking about this, and she produced this report, which is called Chasing Status at that time. She talked about the surprised Brits who were suddenly finding out that they have irregular status. And I was intrigued by this, that what's going on, because I didn't imagine that people who have arrived in 1948 and the subsequent decades have suddenly realized that, well, I might not be and I might not be who I really think I am. And why? Because I cannot produce a certain landing card or a certain thing, which I was never expected to produce at any time until the recent kind of legislative changes. So how did that even happen? So I have a couple of quotes here from Fiona's work here, because I think it captures people's bewilderment to be asked for something like a document for getting the P60, P45, etc. And they're told that these are not enough. You should have something else. And they're like, what? Because I've been here all my life. So that's when I started thinking about this issue and why such things were happening to people. Then we got Amelia Gentleman's book, which, together with her pieces in The Guardian, really looked at the life stories of people who were forcibly deported or who were being detained. And some of these stories are extremely heartbreaking. Like, I can tell you Jocelyn's story in her book it's very haunting. And someone who, after a whole lifetime in Britain, is sent back to Jamaica, a country she doesn't recognize, has no connections with, has nothing to do. And then suddenly she gets an apology and a return ticket back. And she comes back. At that point, she has nothing left here in London, where she was, because she had to give everything away in order to go. So it's a complete story of being displaced and betrayed, really. I mean, scandal is not really the word for this. And again, that brought this whole, the legal network, I say network, but I should say more like a spider's net, that trapped people into this producing documents and having to show their status. So I will not go into the various legislations because I know we have an expert on this who's going to talk about it. But we have the primary 2006 to 2014, and 2014 acts really make it much more. So the 2006 requirement of proving things is magnified by the 2014 requirements that are imposed. And at present, we have the whole issue of e-visas and digital documentation, which just last week, I think the Guardian reported is likely to be a massive scandal if people are not able to come back through some of these digital documentation requirements, and might be another sort of a Windrush crisis happening. So this may look like a straightforward story about exclusion and inclusion through legal status. And it may look like, okay, so this is a state exercising control over who is in which category, who is foreign, who is actually here, and simply putting them into some pre-existing legal categories. So it looks like a very individual account. It's your choice. You don't have these documents. So the blame comes to the individual. But actually, it's not that straightforward. It's not simply a story of state action and inclusion exclusion, because this idea of foreignness is not something that's constant. It actually varies with time. And that's where I think I find it useful to actually think about why in times of empire, it was actually possible to include people in projects like working together in the world wars, and how that was, at that time, it wasn't about foreignness. It was about everybody being in this enterprise together. And then it changes with time. In 48, there's still this residual, we were in this together, so come help build the motherland kind of rhetoric found. Very soon, this then changes into, actually, in the nation-state context, we've gone through a transition now. We are redefining who belongs. Do we still look at that sense of who these people were and how we were in this together? It's shifted, and it changes according to the political priorities. So in my chapter in my book, in which I look at this idea of borders being, transient, and as well as changing in shape and form, and adding to the real lines on the maps, there I look at how from empire times, when people are spread out around the globe, the sense of togetherness has much more space for being diverse, being different, because you're not right here. And when it shifts to the presence being here, that sense of who then belongs constantly keeps shifting with the political project. And that's why we see that there are different hierarchies of who belongs. Some people belong unconditionally, and some people do not belong unconditionally. They are actually conditionally there and can be categorically excluded. And then we see that the 48 Act, it unconditionally says that you can come, you can live, and you can do this. So it appears to be a form of what we call declaratory law, which just simply includes, and you don't have to take any action yourself. You're just included via it. But because it's actually this definition, while it looks like it's inclusive, it still is conditional. And the conditions then are subsequently added by these various legislation, which say things like, if your passport is issued by a colonial authority, it's no longer valid, so you can't come in. If you do not have blood links through ancestry, then you do not belong and you cannot come in. And so these are the conditions that are then added. And so what I would say, it's a sort of a reverse decolonization. We're trying to now say these populations do not belong within this territory. So we get them out. And it's always then prospective exclusions going to the future. So I have a short sort of a graph here to just give you a visual depiction of these successive exclusions. Again, I know our other speakers will come up with the legislation, and I don't want to go too much into it. You'll see each limitation takes away categorically certain people. So at present, what we are having now is with the Wendy Williams report, which, has been difficulty in implementing those recommendations. And apparently there's also a 2024 suppressed report, which merely lays out this kind of sequence of legislative changes, which I just spoke about. So it's known and documented historically in archives there, but still that was kind of suppressed and they didn't want that out, but it's now come out in 2024. And so there's this idea now that who are these people who are encountering these difficulties and what should they do? So therefore, it's so great that we have people here who are working on the solutions and on how do you actually recognize the rights that were granted, that are unconditionally granted, but then subsequently conditionally taken away. How do we work against that? And I think we need to think about it. What are we seeing? It's not just the legal categories that have to produce documentation or the legal categories of who can come in or not. What we are seeing is the sort of national bordering, a post-empire national bordering, which brings in ethnicity and ancestry and blood links much more to the forefront of who can actually belong. So that's how the racialization of who belongs comes in. And it's not an isolated incident. We can see it happening again and again with different categories of people when you get this sort of a transition, a political transition. So in Brexit, for instance, when separation of UK from EU, you again see that sort of, okay, then who do we eliminate in this nation-state bordering project? However, there they came out with what we call a constitutive legal solution. That is, give them a chance to register in the USS, the European EU settlement scheme, which is also sort of exclusionary. If you do not do it, you're out. But it lets you take an action to regularize your status, which is a different approach than what was done for the Windrush. So that's the difference. But in some ways, it's very much a repeating of the national project vis-a-vis what was a continental project when the EU and belonging to the EU was discussed. So I think to conclude, I would say this is really a story of how state power can identify foreignness, and it's not about who is a foreigner as an outsider. It can be about looking inside and then ethnicizing the idea of who belongs, who does not belong, making a difference between the past, setting aside the links of the past. It has also worked in other places in the world. For instance, in the colonial legacy of India after division, and partition into the Pakistan and India. In East Pakistan, which is now Bangladesh, there were Muslim people who also moved towards India or who didn't move towards India. So at that time, it was fluid, but some of them did move. And subsequently, they were Indian citizens. But recently, you've seen in some parts of eastern India, as India tries to break away from, the past empire legacy, there is a resurgence of what is recognition of who is a citizen. And you see religious exclusions coming in there. So in a way, it's a different story, but parallel to this drive for documentation. So they have this registration documents that require from people to prove that they're actually Indian and not foreign, whereas they have been living for generations there. So a similar account. For Ukrainians in areas occupied by Russia, you see a slightly different slant in which there's forced passportization. In times of empire, Russia actually would refer to Ukraine as Little Russia, like Little Russians. And there was no attempt to actually say we are the same people in that way. We're part of the Soviet Union or a project like that. But now there is forced passportization to justify taking over certain lands and say we're actually similar people. So it's an opposite kind of a move. But again, it's about the documentation and, depending on the political project, trying to deal with different issues of who belongs, who does not belong. Am I out of time, Marlon? Good. So I feel like, therefore, we need to think about, is this only about a story of looking for documents? Is this only about how the legal recognition that was given is suddenly just taken away? And is it enough to think about then how we go back against it? Or do we need to think about this whole idea that you can use state power to suddenly exclude people? And that can happen along lines of race, of religion, of linguistic differences, and other kinds of things. So I think we need to think of those things quite critically and try and understand why things have developed the way they have, so that it does not get repeated anywhere or anyone. That's with that. To your place. You want me to come up next?
Yes, please.
Thank you.
Thank you. I should have said there's also in mind.
No, that's all right. I think I should be able to. Hopefully, I should be able to manage. And thank you so much for that really interesting talk. A couple of references were made to me explaining the law. I'm not going to do that to you because I'm pretty sure you're going to start falling asleep if I start to explain to you 30 years of immigration law. But there are some things I want to say about law. But before I do that, I want to explain, it's already been explained, who I am. I'm a barrister, I'm a barrister in chambers. I've been practicing in immigration and nationality law probably for too long, but close to 30 years. I've seen a lot of changes over that time. And I do say to a lot of people in the context of immigration and also in the context of Windrush that my own feeling, and somebody will correct me if I'm wrong, is that there's been so much more legislative development in the area of immigration and nationality than there has been in any other area of law. For example, land law, family law, housing, etc. Huge pieces of legislation which can overturn a person's right and status in the UK, sometimes almost overnight, and this has already been alluded to in the talk, not alluded to, but been told also in a talk you've just had. And I've seen that in my own practice, and in some ways it's been out of our hands. Those are governmental developments, they're policy developments up to a point, and political developments, but we have to deal with them. And as a lawyer, that's what I do in the way that I can. So a couple of people, or not couple, but many people have said to me outside of this room, because I see so many faces that I know who know about Windrush or already here. We need to learn more about Windrush, but some people outside of this room say to me, well, is it Windrush done and dusted? Government apologised, there was a scandal, it's done, it's over, isn't it? Well, it's not, because
we had what we call, what was and is, the Windrush Lessons Learned Review, which was ideally a review of what went wrong and how we can set it right. That sounds great in practice, fantastic. So we had the Lessons Learned Review. We learned a little bit about historical law and the impact that was having on migrants coming to the UK, particularly from the Caribbean, but not solely from the Caribbean, from the wider Commonwealth. And then, so the author of the Lessons Learned Review, probably, I'm sure a lot of you know already, made a number of recommendations. And recommendations are what they are. You know, they're recommendations for people to follow, unless there is good reason not to follow those recommendations. The government, previous government, in their infinite wisdom, decided that they're not going to, well, they decided initially, yes, we'll follow these recommendations, and then decided, actually, you know what, we're not going to do this. We're not going to do all of these. No real reasons given. And so we still find the fight, the Windrush fight is still going on, even though we have the apology, even though we have the scandal, we have the Lessons Learned Review, we have the recommendations, and then the government says, you know what, we're not actually going to follow a number of these recommendations. So myself and some of my colleagues decided to take legal action. We decided to launch a judicial review, so many people will act in different ways. I see a lot of people from the community here, and that's really important to have that community response. But as a lawyer, that's my response. That's the way I would respond to these kind of things. So there was a judicial review. It took quite a long time to get up and running. It was a bit hard to get on track. And we complain that, look, this is a decision that shouldn't and couldn't have been lawfully reneged on, and the courts agreed with us in relation to at least two of the three that was reneged on, which was really good. And the sad thing about that case, there was a good thing and a bad thing, if you like, but the sad thing is that we had to bring that case. Why would we have to do that? There was a Windrush Scandal. There were recommendations. We were told that people were harmed, there were victims, there were recommendations. Why would we have to do that? That's a bad thing. The good thing is that the government told, well, you shouldn't have done that. So that's the good thing, and that opens the doorway for those recommendations, which is the Migrants Commissioner, and the review of the independent commissioner for or the body for the Borders and Immigration official, and for the review of that particular role, the ICIBI it's called. We now see that the new government quite hasn't implemented those two recommendations that the court said were wrongfully not proceeded with, but the government have decided to start with at least a Windrush commission. So let's see where that goes. So that was that case, and then. What we know is, of course, the government said, well, what previous government again, 2020, we're going to, or just before then actually, we're going to introduce compensation for those victims of the Windrush Scandal. That sounds great, fantastic. But then what we see is clearly some people have got compensation, some people have got probably the correct level of compensation, but there are quite a number of people that haven't either got compensation or got compensation at the right level at the right time, meaning that they have to apply for a review. So it's not an appeal, but it's a bit like an appeal, so they have to apply for a review. All of that takes time. So I want to talk about a particular case. I know the solicitor is here who deals with this case, about what the court is doing with the compensation and the ability of a Windrush migrant to apply for compensation. So what we know is that you have to fill out a form, you have to say what your loss was, you have to say how you suffered that loss, your loss of employment, loss of accommodation, perhaps difficulty with your family, all sorts of different things. And we also know that many of us anyway here will know that filling out those forms and dealing with those forms and making those submissions can be complex. But what happens is when you make those applications for compensation, you are not entitled to have legal aid to help you to apply for compensation. So if you don't get legal aid, how can you get the right level of compensation? I appreciate some people will, so I'm not saying that that needs to happen in every single case. There are very many victims of the Windrush Scandal that are not able to make these claims themselves. They can be legally complex. They can have evidential complexities. They can be issues surrounding what we as lawyers call quantum, which is all about the assessment of, sometimes we call it damages, but the assessment of what you are entitled to by way of compensation. That can be really complex assessment. And so in the particular case I'm talking about, the application was made to the compensation scheme, Windrush compensation scheme. The application was refused, but the application was helpfully made pro bono by someone not too far away from me, and the application was refused. The Windrush compensation scheme application was refused, and also the application to the legal aid body. And what the legal aid body said was, and I'm trying not to get too technical, so we don't want to get too technical here, but essentially this doesn't really engage what we call a civil right. It's not an Article 6 case, Article 6 European Court of Human Rights case. There's no dispute here. You're just making an application, there's no dispute. So that's one of the points that the legal aid agency made. The second point is saying, well, look, they don't engage, this claim compensation does not engage Article 8 of the European Convention of Human Rights. You could see a lot of lawyers within the room tonight, and I know not many of you will know what it's all about. Well, you think about a claim under full compensation, which is a Windrush compensation claim, where you have suffered losses, where you have been a victim, where you've been outside of your accommodation, for example, separated from your family, difficulty getting employment. But the legal aid agency, that doesn't engage Article 8 of the human rights, of your human rights. And then the third point that the legal aid agency say, which is why you don't qualify for legal aid, is that there's no discretion within the statute, the legal aid and sentencing and punishment, we call it LASPO. There's no discretion within that. So they're actually front-loading this. They're actually putting a lot into this, saying that you cannot get a legal aid. You, this individual, cannot get legal aid. And the reason for that is because they don't want that to roll out to other Windrush victims. My one point I will say about this isn't a wide-scale group. It's an ever narrowing group in any event. So that the concern of the legal aid should not. The concern of the legal aid board shouldn't be a real concern, because it's a very, very narrow group in any event. But apart from that, it's very unsavoury, really, that the legal aid agency are really taking this view. They're an arm of the government, albeit they're an agency, I get that. But these are victims, and the state has accepted that they are victims of state harm, and then an arm of the state says, well, I'm not going to help you to get compensation. It's not acceptable in my mind. So the case has been taken to these cases have to go to judicial review because they're appeal rights. So it's gone to judicial review. The judicial review was dismissed on grounds which myself and my sister feel that were not sustainable. So the next stage is for that case to go to, well, we've applied to the appeal, they will not get permission, but if we don't, I feel that there'll be another case where we can try to do that, because it seems to me to be fundamental that you should be able to have funding to challenge decisions that are made as a result of harm caused by the state. So I think finally, the other case I would talk about is a case where, again, in the High Court, where the Home Office would have rather granted status to some family members, but not to another family member. And again, what we see is the Home Office in those cases trying to unpick what has happened in the past in relation to individual family members, which again I understand, because people come at slightly different times. But quite often the distinction is one without a real difference. So what we see is that amongst family members, we see some of them who pretty much have the same background, getting a grant of status indefinitely to remain, subsequently citizenship, and someone else who came a couple of days later or who was slightly over 18, not getting it. And also the Home Office in that case was saying, well, you know, your father could have done this at that time, could have done that at that time. So really trying to make a difference, in my view, without distinction, to separate the decisions in the case of the family members. And again, that's the case that's going forward. So those are some of the cases that I've been dealing with. There's a whole range of others. Some of them are coming to the court arena. A lot of them don't. A lot of cases that I deal with are advisories or advising their stage by stage. A number of them settled, which is good. The Home Office just accept that they were wrong, or that they can actually make a positive decision in a particular case. That's really my experience of Windrush, and I'm very happy to have shared that with you, and thank you very much for inviting me. Thank you, Greg.
Thank you all. My name's Anthony Brown. I'm the co-founder of Windrush Defenders Legal Community Interest Company, and that came about in 2019 as a result of the Windrush Scandal. And a number of us from the community got together when we heard about the scandal and formed a group and started to help each other. But I was born in Jamaica in 1960. My father had come to the UK as a citizen of the United Kingdom and colonies. Now I'm going to give you a series of law. I'm going to give you my story because I think it might help for you to get a grasp as to what's been happening if you've got so many stories to relate all these different changes to the law. And also to involve my two sons, because we often hear of the Windrush generation and their descendants. We never see or hear from the descendants. So tonight I want to allow you to hear their voices in terms of what we see as the way forward. So, I was born in Jamaica, came here in 67. My dad had come here as a citizen of the United Kingdom and colonies under the 1948 British Nationality Act. So the reason for that act, which is what we don't have to often get of the law, is the stories behind it, was that at the time, after the war, a number of colonies were being given independence. India was going independent, Canada was going independent, England was going independent. So who were then going to be the British? Before that, you saw allegiance to the king and you were a subject and everybody was a subject. But now they wanted to create a statute law to determine who was a citizen. And so the British Nationality Act 1948, Section 4, declared that if you were born in the colonies or you were from the UK, you were a citizen of the United Kingdom and colonies. So my dad had the same rights as people in Scotland, people in Wales, people in England, to come and go, freedom of movement. And so he came, so did the people who came on the Windrush, because they came after that law was passed. And so they were able to come, just getting their fare and for the boat and coming. But then when independence came along, everybody was cheering. Jamaica was getting its independence. But unbeknownst to them, Section 2.2 of the Jamaican Independence Act says that on the 6th of August, those people who were born in Jamaica are going to be Jamaican. And so Parliament removed citizenship from whole swathes of people without them getting any notice. They were there cheering for this flag and this anthem, and they didn't know that their freedom of movement had been changed for hundreds of years. Their ancestors had been enslaved, and they'd contributed to the empire by force to build up all the infrastructure, institutions, and all the rest of it. And suddenly, they were now not allowed to come over and study, not allowed to come and work, because Parliament said their colonies were independent after, hundreds of years of taking from those colonies. We didn't even get a divorce settlement like what happened with Brexit. So they got their flag and their anthem, and my dad was here, living next door to his white neighbours, not knowing that his rights now are fundamentally different from what his neighbours were. And so we came over, and then the government passed the 1971 Immigration Act. Now, immigration acts don't apply to British people. So we have all these complications about the law and how many immigration laws have changed. But really, we could sweep all that aside if those people who lost their status regain their status. The immigration law would apply to them. But with my case, because my dad had had his status taken away, my status had changed. And unbeknownst to me, we went back to Jamaica. I stayed longer than the 2 years that the Immigration Act had said. And when I came back, unbeknownst to me, I had lost that resident status. Got to school in Jamaica, gone to Jamaican college, and then I came here and wanted to go to university after going to college, and wrote to the university, the Home Office, because the college was telling me they were treating me as an overseas student, and the Home Office wrote back and said, actually, you are an illegal immigrant. You've been out of the country for more than 2 years, and you need to report to Manchester Airport to be deported. Obviously, that was a shock. Didn't know anything about it. Neighbours didn't know anything about it. Went along to the community centres, and there was somebody in one of the centres called Gus John. He was a community activist, and he chaired a campaign that led to Margaret Thatcher actually relenting and allowing me to stay, because she'd come to power saying we were swamped by immigrants, and nobody got anything past Mrs. Thatcher, but eventually she changed her mind and allowed me to stay. But that trauma lasted for some time. I didn't go to university. This is some of the information that we put out. Last year, I was at a meeting. Somebody from the archives in Manchester said, "We've seen some documents that look like you. Would you come and see them?" And so we took the boys and we went up, and I was confronted with myself when I was about Lucy's age, and it had an impact on me because I remembered all the trauma that we went through. And my son George looked at me and said, "Dad, it's a good job you mother, or else we wouldn't exist." And that too was something. So moving on, how could they want to deport us? You know, we carried on, got married, had a family, but then things changed, and I decided then that, you know, I hadn't done my law degree as I wanted to do. So, you know, the Open University, which gives us a second chance, I applied to that and did it part-time for 6 years. Graduated because one of the reasons was about being a competitive dad, because my sons were getting to the age where they soon were going to university. I'm thinking, I've been encouraging them all this time and I haven't done it, so I've got to get it before they do. So I did the Open University just at the same year that I graduated. George was graduating as well from this university, Goldsmith, so it's pointing that we're here tonight. But also Lewis had got himself a place at Oxford. And I thought, wow, the three of us have sort of moved and are achieving, despite what happened. The country does still give you a chance. So I wouldn't, you know, trash Britain and say it's all, you know, racist and everything. Yeah, there are bad things that happen, but, you know, there are opportunities as well. And the Windrush Scandal broke, and I saw the same sort of things happening to people that attacked me. I called a number of people who had been involved with my studies at the Open University. Oh, this, by the way, is me graduating, and that watch you see in that clock is a gift for my sons for passing my exams. So the time had come. So yes, when the Windrush scheme came about, I applied to the Windrush scheme, and within 3 weeks of me applying, 3.5 weeks of me applying, after 35 years, I was given my citizenship back. And we also helped other people to get their citizenship as well. We formed a team, Windrush Defenders Legal. So this is from. On my right is, at the end is Rochelle. She was a law student. Naomi is on the Open University course as well. Lorna Downer, she worked in the community. And Tanika Stevenson, she was also a university student. And we met at the Windrush Millennium Centre, a group of us that, you know, developed into a national network, Windrush National Organisation. But there's other people getting their certificates. My son, who wanted me to take him to Jamaica, couldn't wait any longer. He decided to go off by himself, and this is my old school that he visited. So one of the things that we thought of doing was to try to find out what we needed to do about the impact that this had had, because it impacted on education, and when we were doing the searches, we found out it's impacted on health, and so on. So I discussed this with my sons, and I'm going to ask George now to come and tell us briefly about burning work, and then Lewis to just tell us about one of the aspects that we're working on with education.
Hi everyone, I was really hoping you were going to start reading my slides then. I could stay hidden away. So yes, telling you a little bit about our involvement in kind of drawing burning work. So I'll start with this kind of slide. Further focus in campus, the work is burning in the fields. So a few of you might recognize this phrase, a few with a particular elite education. It's the motto of Jamaica College. So that was me visiting the college that I did go to. And it's the name, so burning work is the name given to the work we started to undertake, unraveling the effects of the Windrush Scandal. So to understand the wider impact of the scandal and the events that led to it, Channel's research group, which was founded by myself, Christopher Oliver, Sarah Burke and Jerome Bond in 2018, when we were just in our final years of the university, along with the Reading Legal as well, we created these intergenerational discussions with elders, scholars, and experts in their field, and those with historical knowledge of our communities. As each working night turned into early working mornings, and then the following night and the next day, we indeed agreed that it really was burning work, but not quite the burning work of our ancestors, but no doubt continuation of that same struggle. The Burning Work Conference brought together those eclectic individuals to create a forum in which intergenerational and interdisciplinary discussions could be held. Recommendations were created and a report was published. The disparities were decimated into 5 distinct but connecting themes: community cohesion, criminal justice, education, health and work. And an agenda was drawn up to activate projects that would work to rectify race disparities in each of those key areas. So following the conference, we were approached by the Black and Asian Police Association of Greater Manchester Police, wanting to kind of work along with us to create something similar as those discussions that we'd had at the Burning Work Conference. And that project's outcome really taught us that certain structures and commitments needed to be in place to identify problems and remedy them. So that's where the Burning Work Protocol was created, and instructed how coalitions of intergenerational and interdisciplinary individuals could and must be brought together to discuss and advise policy design, and with thorough documenting and archiving of the proceedings. That latter element, the work's potential benefit to future generations. And so that gave forth to the archive component, and you'll see the image on the right there. The archive component furthered this element. It was structured around 3 sessions featuring sound presentations and speeches from the Windrush Defenders and the Allied Lola Race Centre, which is situated in Manchester Library, and their community networks. Invited practitioners to address the themes of archiving as anti-racist practice, evidence of racial inequality, and archival transmissions. The forum was broadcast live within the full performance space of Manchester Central Library by DTA Radio. The assertion in Wendy Williams' Lesson Learned review of there being a lack of institutional memory rang true in most institutions we interacted with. The impact of this forgetting would forever go on to harm future generations of our communities, even if we had the structures in place to consistently remedy disparities and create new policies. There had been a tap left on that would forever continue to pour problems on our communities to face, meaning that much of the best of us would either be forever stuck solving problems or working in areas that would not benefit our communities and potentially make them worse. A plug was needed to fix that leak, and I'll invite my little brother just to talk a little bit about a research project he was kind of starting on, that kind of looked at addressing some of those racial disparities in work. Got enough time? Yeah.
So I was inspired by cost benefit analysis of wedding petrol in the US by an economic analyst called Joel Schwartz. Showed that because lead exposure can lead to lower IQ in the population, it has a significant impact on the economy. And this was a time when he wants to relax regulations on lead petrol. But after this analysis, lead petrol was banned in the US. And I was thinking about how a similar analysis could be done on racial inequality that could influence policy change. So I found a paper by some American economists whose name I thought I was going to push it before, but seeing how I handled the word economic analyst, Pierre, Hurst, Cornell, and Jones. The paper was called The Allocation of Talent and UX Economic Growth. The idea is that when there's poor representation in skilled roles, then there are people who are talented enough to do those jobs, but who aren't in those jobs. So there's underutilized talent. So, for example, 1% of judges in the UK are black compared to 3.4% of the working age population. So there's a disparity, but it's not as if black people lack some kind of like innate talent required to be a judge or something. And so there's underutilized talent, and when we have talented people who are working well in highly skilled jobs, that helps it come. So the paper points to 3 forces that can lead to people of a particular demographic choosing jobs where they don't have a comparative advantage, or getting into jobs that they don't have a comparative advantage. First is discrimination in the labour market. Second is barriers to forming human capital. So human capital meaning education, experience, skills, training, connections, anything like that. These kind of things that can help you be good at your job. And third is social norms and preference. They used an economic model to pick out the contribution in each of these forces. And what they found is that from 1960 to 2010, reductions in those forces accounted for 20 to 40% of growth in US market GDP per person. So a huge chunk of the economic growth in the US has come from a better allocation of talent. If the first 2 forces were removed entirely, so if there's discrimination in the labour market and no barriers to education and training, then according to the results from this paper, US GDP today would be 10% higher than it is in reality. So, along with the paper, these researchers published a table of figures that they used, the figures that they used in the analysis. So, for example, like the average wage of a black female American lawyer or judge in the year 2000 with a certain age range. And they also published the computer program that they use to make the calculations. And so my plan was to find equivalent figures in the UK and adapt the program where necessary to use these figures. And this would give an estimate of how much increased representation in highly skilled jobs has contributed to the growth of UK GDP. So where I am now, I've adapted the program to a UK data source, but I'm not sure it's the best data source. So because there's some problems with that, could go into, but I'm not sure if there's time in the law or if it's necessary to go into a particular problem. So yeah, that's my research.
Thank you. So you can see that there's a completely different approach from the minds of the next generation. Before I, was growing up, you were told racism is bad and it's been a moral issue. But somehow or other, the young people have this idea about economics. And what are now looking at is as an economic issue and, how the country could, increase its GDP by removing these barriers, which quite obvious and self-evident in, why it is that at the moment with education we have, such a disproportionate amount of African Caribbean young people and mixed heritage African Caribbean young people being permanently excluded from school, and also with education attainment, 8% of young people in the black African Caribbean community achieve 3 A levels. For the white British, it's 11%. For the Asians, it's 17%. For the Chinese, it's 25%. Why do we have to be at the bottom? We are just above travellers and gypsies who are perceived as not going to school. So the next generation is looking at this and saying, we need to support each other. And we've developed a mentoring program called Spark Mentoring. And we've done it in conjunction with the Home Office, because we're saying to them, Wendy Williams has said, you caused harm, how are you going to repair this harm?
yes, you're giving out compensation, but what about the rest of the community that says has been harmed? And what we're saying is the Windrush Act needs to amend the Windrush compensation scheme so that organisations working in developing education, like Saturday schools and so on, could get strategic funding so they can develop a 5-year plan as to how they're going to tackle these disparities, how they're going to remove these barriers and show it through, how they can increase GDP and measure it year on year. And this goes across the 5 themes: disparities in health, there was disparities in how the immigration laws impacted on the African Caribbean community disproportionately. The people that are affected, although Britain's empire spread are, African Caribbean, particularly Jamaicans. And we're saying that these disparities now have, gone into health, gone into criminal justice, and we've had the historical Windrush Scandal report that now confirms that, people deliberately designed laws to keep out black and brown people. So they didn't do that with their mindset just on immigration laws. It must have happened with education, because we have laws that said some people are educational, some normal, and then they were deported as well through the Education Act. And we can see the figures in health. Black women are 4 times more likely to die in childbirth. Why? And so we want to do the research, archive our information, and then as a community, benchmark where we are now and have plans in which we can develop this. When we put a proposal to the Home Office about changing the laws, because when the Windrush Scandal first broke, and I thought, this is crazy, what do we do? I was talking to a lot of lawyers, and lawyers are always telling me what the law is. But it's for us, the society, to say what the law should be. And through our representatives, we're saying this is what the law should be. We want to disapply Schedule 1 of the British Nationality Act. That sets out various criteria that you have to meet if you want to get your citizenship back. You've got to be of good character. You've got to be in the country 5 years before you can apply. You've got to be able to speak English. You've got to intend to live in the UK. Now, some of them, you've got to pay a fee. Some of those, when the Windrush Scandal broke and the government made what is called a Windrush statement, it said the community was British in all their legal status, and they waived the fees, they waived having to speak English, because most of us speak English anyway, but they left in place other criteria which the ordinary British people don't have to face. So we're asking the question, government's now coming to power saying they want to reset, we're a different government, we want to reset. Reset to what? We're saying you should reset it to what the law was when my dad was here, you took away his status, reset it so that that generation will still have that status, and then their descendants will have that status. And all that stuff about immigration law and whether or not you meet this criteria and that criteria fall away. It doesn't have to be so convoluted. And we got this idea because we took this Home Office to court. I graduated, and the first people I decided to take to court was the Home Office, because my good colleague Grace Brown, we met at a TUC conference. She heard me talking, I heard her talking, and decided that we needed to talk. And then this came up. She said, "You've got a 50% chance." I said, "That's enough." And so, I had great pleasure delivering the correction protocol to the Home Office. They said, "You're taking us to court?" Yeah. And so we actually put them in the dock, and we got our day in court. This was a permissions hearing. So, are you going to be able to get a hearing? We didn't get the hearing, but the judge gave us our day in court. It was only supposed to be half an hour. But he went on all day because he wanted to get to grips with the issue. Justice Warden, and he told us about lots of cases that had gone before in law and through the Windrush Scandal. Why it was that he couldn't give a commission's hearing, because he said it's a matter for Parliament. And so my good friend Ben said, "Oh, well, we must lay siege to Parliament and leave the courts alone, leave the Home Office alone. It's not them, it's Parliament." So I'm saying that tonight, this is what we want to do in terms of a community. Yes, bad things have happened, but it's up to us now to say that this is not what this country is about. Maybe in the 50s and 60s where people didn't really know these people were coming, but it's different now. And it's great to see people from the Lancashire Housing Group who have been so on while having discussion and have seen our journey with the Home Office. And it's great now to be able to discuss some of the solutions here with everybody tonight. We want to see people write to their MPs and support the Windrush Act. Thank you.
Hello. First, I want to start by thanking Carl Stitchell for this invitation, and Marilyn for all the hard work you've done in organizing. It's been a real honor to be on this panel with such wonderful, thoughtful, committed speakers. And I just have really a few comments because I think the goal is to turn it over to all of you to really open up the conversation about this. One of the things that strikes me is that we started with Devani providing a kind of socio-legal historical context to what's come to be known as the Windrush Scandal. And then we heard from Grace about legal advocacy, and then after that, Anthony and George and Lewis about political advocacy. And this makes me want to pause and talk about citizenship for a moment in a slightly different way. Because citizenship, that is the topic tonight, is of course about the legal citizenship, the kind of passport holding citizenship that we all know about. But there's of course another story about citizenship, and it is the story of sort of the legacy of Greek and Roman ideas of citizenship as participation in democratic decision making, as being both the lawmaker as well as subject to the law, about being engaged as a citizen, about acts of citizenship. When we talk about somebody being a good citizen or an engaged citizen. And really what we heard tonight, what we have been hearing, particularly from Anthony and his sons, is about that kind of citizenship and what a powerful force it can be. And there is something kind of wonderful about that kind of citizenship being displayed and empowered, being developed and leveraging in the service of that other kind of citizenship, legal citizenship. And I think it is a real testament to the capacity of people to come together and bootstrap their own citizenship in the face of what is a kind of state denial of it. So I just want to begin by saying how impressive and remarkable that is. So I'm just going to make just a few comments that are a little bit random, but I hope you'll indulge me. So one is actually about technology. So now in migration and citizenship, we talked a lot about AI and the role of artificial intelligence and technology as all of the impact it's going to have and how the state can use it and possibly abuse it and what its virtues are. One of the things that comes out so clearly from what we've heard is paper is a technology. And states can use paper, the absence of paper, to achieve objectives, to impose forms of power in ways that are often not very accountable, but very, very potent. Right? So this idea of, as I think we heard, that people lack the appropriate documentation. They don't have the right paper. And because they don't have the paper, they are not recognized in law. They are not visible as citizens. So there's something about paper that's doing the work here. The paper means more than you who are present and the history and the life that you have. Right? Paper's a technology. And sometimes it's about having the paper, but more often it's about not having the paper And so you don't really exist. And we think about how technology can work that way, that the technological version of you is more real to the state than you are. And I think there's something really important in what we've heard about being reminded that paper too is a technology that can be used and abused. Something else that I thought about, and this is, I'm an outsider here, I'm from Canada, and one of the things I have followed in my own work and writing is about citizenship deprivation in the UK, which is, that idea that those who are the citizen, the UK, the Home Secretary can withdraw citizenship from somebody when it is conducive to the public good. Now, I've sort of done some work on that, right? That's sort of formal legal revocation of citizenship. But of course, what we've seen here again is how paper can be used to effectively remove citizenship in ways that are often less visible, right? So it's you don't have the right paper, so we don't see you. We don't recognize you. We repudiate you as a citizen. Okay? It seems less spectacular than the kind of force of we're going to deprive you of your citizenship. But this is the effect it has, right? You are no longer recognized as a citizen. And so I think there's a link between this that the UK government feels comfortable doing, stripping people of citizenship, something that it's kind of at the forefront of the world now in doing. And I say that not because it shouldn't really be a badge of pride, but how doing that also can slide into other techniques of taking people whose citizenship is seen as undeserved, who are seen as unworthy, and all of this is highly racialized as being second-class citizens into not citizens at all. So I think there's a continuity worth noticing about what I would call the de jure, the legal deprivation of citizenship, and this de facto administrative repudiation of citizenship that it's worth noticing. And this actually leads me to one of the really important elements of recognizing this as a larger political movement, a larger claim of citizenship that is about structural racism. Not the Windrush Scandal is not an cannot be understood in isolation of structural racism that came before, that is manifested in the Windrush Scandal and all that has followed it. And I say this, to just make a casual observation that in Canada, we have this problem of people whose citizenship actually kind of fell through the cracks and wasn't recognized. And there were problems because the citizenship statute changed over time and people who thought they had citizenship turned out not to have citizenship. So that sounds a bit familiar, I think, but it's not. First of all, everybody who lost their citizenship through that, they weren't racialized. They were problems that were solved, sometimes messily. So I don't want to say that it was, it wasn't a problem. It was. It shouldn't have happened. It did. But those people were called lost Canadians. Those were people called not citizens. They certainly were called people who lacked the right paper, as if they should have known that they needed this paper. Right? So the idea of you lack the paper presupposes that you should have known all along, generations ago, that you would need this paper. But if you didn't need the paper then, at what moment were you supposed to know that you should have those papers and go back in time to find, to recreate them, right? But so these problems happen elsewhere, but there's something important about being called the lost Canadians and it being a problem to be fixed, as opposed to you're the problem because you don't have these papers. It's not our problem. Like that's I think that's a significant difference. And this just leads me to think about what Grace described as the denial of legal aid, as not here as a kind of judicial decision that perhaps has not grappled with the structural dimensions that I understand this movement that you're working on is trying to foreground. Because if you did understand the structural dimensions of it, the harm doesn't begin and end with the Windrush, the particularities of Windrush. And indeed, there's a real echo of what I was saying about paper as a technology and this, all you got to do is fill out the form. You don't need a lawyer for that. Well, it kind of depends on what that form demands of you. It kind of depends on what your capacities and resources are. And none of those things, and do you have the money to hire a lawyer? Well, none of those things can be understood or thought about outside of this broader context, broader structure of what came before, what led to, what caused the Windrush Scandal, and what has come after. And so the idea that you don't have an entitlement to legal aid, nobody's bringing a case against you, you're just seeking compensation, is to miss the structural dimension of what happened here. And so that, in fact, the very capacity to bring the claim for compensation and a remedy is shaped by the harm that you are seeking compensation for. And to miss that, I think, is to miss what I understand the larger struggle of Windrush and the generations of Windrush are in a struggle to respond to and to combat. So thank you very much. I'm going to turn it over to Paul.
And it's opening up to you now for Q&A, so please.
Good afternoon, everyone. My name is Dr. Yvonne O'Connor. I'm a Windrush Delta. Particularly next to the Windrush National Organisation, they help people every year. But I'm an activist as well, and most of my activities have been about trying to engage with this Home Office. We call it the Home Office Scandal, not the Windrush Scandal anymore. In most because the Post Office Scandal isn't the people who were victims of it. It's not them that's the scandal. It's the Post Office that caused the scandal. The Windrush generation didn't cause the Windrush Scandal. The Home Office caused it, and the government caused the Home Office Scandal. So I'm getting tight. I should have claimed by now for my mum, who's 94, just left the she's been out. So a couple of these legal things to be trying and the rest of it to be involved with it. And the 94 was sort of like surprising. She's not going until she gets justice. We saw it last week, somebody at 108 in Jamaica. That some people aren't going to leave until they get justice. But so many, as some sisters said, have died without justice. And that is the justice denied, which it's not a justice. And so I'm trying to get to my point. I worked in the NHS for 40 years, and I was part of the 2010 Equality Act activism that we've got that isn't working either through the courts. But we can at least compare that sort of legality to the legality or the illegality of the Windrush scheme. I've taken the NHS to court twice, and each time I'm the victim. There's a perpetrator who's the employer. There's the judicial system, the employment tribunal, but it's also a mediator. And there's a comparator, i.e. my colleagues who have the similar qualifications to me, who haven't been treated that well, or the colleagues who the similar qualifications to me, who aren't disabled or aren't black or aren't going through the discrimination I've had. So when you look at disability discrimination, it's not up to the disabled person to fix the lab or fix the hospital or fix the employment space so that they can work there. It's up to the employer to fix the space for the person to work there. And we as activists now, have turned to this new government and said, with your reset, will you take this job away from the Home Office? They're the perpetrator. This is the only scheme in the blood transfusion. I mean, I've seen my sister there that's done the research from access to race equality. It's the only compensation scheme with rent bill, etc. that you're asking the perpetrator, you're asking the rapist to take a case to court against you, claiming that they raped you. That's how, I mean, that sounds really extreme, but that's exactly what it is. And that's why there's such a low pickup in the compensation, because the victims, say survivors, the survivors don't want to go back into the belly of the beast, don't want to face. I can't, every time I go to fill in the form for my mum or my family, my sisters, I am triggered, I'm traumatized. You're re-traumatizing the victims. So I'm not a person of no, I'm a person who's strategic. Let's make solutions. First thing is that we need to all take some kind of, the ombudsman, that's one of the places where we can complain, because we can't get the government or the Home Office to police themselves. It's like going to the police and asking them to police themselves. We need to have a strategy where we say, this isn't acceptable, this is against the law, it's illegal actually to ask your perpetrator, to ask your rapist to apologise for the harm they've caused you. So we need to have some way of bringing that to the government, to the we need somebody else outside. And this government has said, oh, but if we do a reset and we'll take it away from the laws, it's going to take forever. We've got all these arbitration systems, we've got ACAS, etc. So we need to take those things into consideration, and the people who've already got their status regulated, they couldn't get their status regulated in the 80s and the 90s when this first, when the 84 law came in, because they were broke, they were literally working hand to mouth, second-class citizen status. So you're not going to be, my mum said, I'm born British, I am British, I'm not going to pay to become British again. They went from 500 to 1,000 to 2,000 to too much. So she stayed under the radar for these last 30 years until she got her 58 years of which she waited to get her compensation through the scheme. But they don't get any, they're not compensation, she got her status renewed. Those people should all be given the basics, at least the minimum is 10 grand. They should all be given the 10 grand for the fact that they've been denied that status for the last 10, 30, you say 2 years, 30 years, they waited. My mum waited 56 years. But the second thing is, that the final thing is, that the post office starts at 600,000 and Windrush starts at 10,000. The post office is 88% pickup, the Windrush scheme is 20%, being received. So it sounds like a big long speech, but what I'm saying is, the law is not something that we can use if the law is illegal. And we need to to recognise that the law isn't working. It's illegal from the start to finish. We need to go to the ombudsman and say, on maps as a campaign, I would propose, that we say, this isn't working.
Okay, thank you so much.
Sorry, it's really traumatising, and I feel that...
I can hear that.
Yeah, I think it's unacceptable. I think
Thank you for your contribution. I'm just aware that we've got some more questions from the audience. Okay.
You briefly mentioned the transition to e-visas, that people will stop having physical papers and move to electronic status. And to have your electronic status, you need a UKVI account. And in the terms and conditions of the UKVI account, the Home Office excludes themselves from all liability for any problems caused by the UKVI account. Are the Home Office capable of learning the right lessons from this, or on the wrong ones?
That's literally the point in the reports that are now coming of people being stopped and their visas not working suddenly. And you can see that, that's why they're calling it the digital Windrush next version waiting to happen and happening already. That's the exact point. And again, I think, as you mentioned as well in your speech, Audrey, it's the documentation issue and another technological manifestation now from paper to paperless, but you can see the similar kind of exclusion again.
Thank you, Deepali. right at the back.
Professor, my question is around the inside, outside. From your research, has there anything you have found where case law has applied to people who are being considered outsiders? Is that concept that with this research a lot? And the question is, have Parliament ever been looked at the concept of outsiders as opposed to you not being a refugee and if you should have the same legal status as people who are UK citizens?
That's actually a very fascinating question because I think in your question, we see kind of like what is universally applicable to all. Like, can we talk about human rights just by being a human being present, and what is over and above that is being carved out for citizens, and then what is then available to the others who may not be asylum seekers but are also not considered within citizenship or subject to transitional time. So where would we put them, and would they be, is that under human rights or is there something else? So because somebody mentioned here about, I think it was Anthony, about how immigration acts should not be what we are talking about when we are talking about people who came under the 1948 Act, because they had a status there. In the British context, actually, where nationality and immigration and asylum seeking are conflated, it's sometimes very difficult to even know if somebody is in one category or the other or third. And so the question you asked me, I can think about when East African Asians came to the UK, they had British passports. Those passports under the 68 Act, they started saying, 62 and 68 Act, they started saying is issued by a colonial government, so you're not a citizen, so you're some kind of an other. They were also fleeing persecution, but you are not really an asylum seeker because you actually have a passport. And so who are you? You're not somebody exercising a citizenship right despite having a passport. So you're not really an outsider, but you're not even an asylum seeker. So at that point, it became actually a human rights case about the right to enter and be here and not be illegally detained. So they brought about Article 5, they brought in discrimination, Article 14, Article 3, because some of them were also detained and tortured, and the inhuman and degrading treatment issue came up. So I think there's a whole range of possible rights we can talk about. But the idea of citizenship being this is the exclusive domain and you should be getting it as an entitlement, that doesn't happen that automatically. Then you have to struggle through those other instruments and try and establish that. That's good.
Yes.
Hi everyone, I'm Kim. I'm from Action for Race Equality, and I can't take credit for that report because I was actually written by King's College London. I just quote it a lot, but I didn't actually write it. So I'm going to take credit for that. But I wanted to hear more about the Windrush Act and whether within that there would be, because I'm not a lawyer, so I want to take the opportunity while there's lawyers here to ask if there's scope or the proposals to change nationality law would then remove the need for something like the Windrush scheme for documentation, because obviously there's lots of issues with people not coming forward because they're worried about the risk of deportation or accessing that scheme. It's in its simplest, the government says that it is, and the form isn't necessarily as easy and the evidence needed isn't as easy to access as people say it is. And so in those proposals, would it be looking at making that cohort that's mostly affected by the scandal, for want of a better term, like just having their rights affirmed without having to go through a process? Is that what's being?
Well, I'm probably going to let Anthony talk about that. That's something that the Windrush Defence League, have been working on, and maybe even George might be. I'm not sure if George can talk about that. Certainly Anthony. But you say that you're not a lawyer, as we've told us, that there's a process for law to be introduced, and I'm sure you know, probably you don't need to be a lawyer to know that you can't do that overnight. So this isn't something that's even at the doorstep of Parliament at the moment. So it's not going to be this year, it's not going to be next year, it's what is being talked about. And in terms of, rights and trying to increase rights for nationality, there's other ways to do that in the meantime, which is through challenging actually legislation. Whether you think the legislation is right or wrong, it exists. Individuals are suffering at the moment, so sometimes outside of the country, and you need to show why they need to come in and why the legislation is wrong or doesn't apply to them. So that's one of the ways that you can address some of the inequities that are currently happening now. And if and when the Windrush Act gets any further, then we'll see if there's any further developments in it, and to say a bit more about that.
So the Windrush scheme, well, that's the government scheme to give people back their status after they declared their ruling state in Parliament that British Irish or British status. Those are words, but do they mean anything in law? So when we get to the High Court, lo and behold, it didn't really mean anything. So the judge had to try to determine that. So at the moment, anyone who came before 31st of December 1988 is eligible to apply for the Windrush scheme. That date comes in because the 1981 British Nationality Act it gave a period of 5 years for each register. So it came into effect in 1983, and then at 5 years on, 1988. Now, in the 1981 British Nationality Act, it has a schedule of who can register and who would have to be naturalised. So if you came from a colony and you then were a citizen of a colony, you could register and get your citizenship from the Home Office. If you didn't, you'd have to naturalise and meet these criteria. Now, the opportunity to register was rescinded, I think it was January 1988. So you could no longer register as a citizen. So when I came to apply under the Windrush scheme, although I had come in a period where I could have registered, because that part of the law had gone, I had to naturalise. And they applied with the criteria to me. Had I been in trouble with the law? Had I been here 5 years before I'm applying? Did I intend to make Britain my home? Do I have to pay a fee? And so on. And for some people, they don't meet that criteria anymore because they got arrested under the sus force, or they had an altercation with somebody who was chasing their wives, and they lose their right to register the system because of that. Yeah, the next British person doesn't have that problem. So what we're saying under the Windrush Act is if you disapply Schedule 1 to all these people who came in that period from a certain geography, then you can't go and ask them, have they been in trouble with the law? You can't go and ask, the Home Office can't ask them those questions because they're local. Also, with all those criteria, the law will say you have to be here 5 years or you have to be a good character. What is good character? The Home Office has to set up guidance as to what that is, and that's where the convolution comes in, because they've got all these guidance that you then have to jump through. If it says you have to intend to make renewal, what does that mean? They set out guidance, and that's where it becomes convoluted. But if the Windrush Act comes along and Parliament votes that you disapply this, then the Home Office then has to sweep away all that guidance, all those types of application bits, and it'd be a lot easier in our view. Now, I want to make a point about what someone said about taking the scheme away from the Home Office and the Home Office being the arbitrator. It's difficult to keep saying it's the law. We're in this position because there have been changes of law, so we're barking up the wrong tree when we go at the Home Office, because the Home Office is just the agent who enforces the law. Change those laws and the agents will talk a different story. That's why we're working with the Home Office to get them all changed.
Thank you. Thank you. Do we have other questions? Yes, sir.
Thank you very much. Yeah. You will know that I remain late. That was not trying to degree from 5 o'clock. I'm trying to get here. Let me ask one question and then address the matter that you just outlined. Have you all looked at the origin that brought about the Windrush generation scandal announcement? Have you associated the Windrush scandal with the 1959 Mental Health Act? I'm asking, have you?
Yes, I did mention about people with mental health being deported as well. So that's part of laws that were made because people had this idea that we're going to keep out black and brown people. So that's what the historical roots of the Windrush Scandal said.
But I think you also mentioned education and
Yeah.
education law and the impact of legislation, Mental Health Act, maybe not specifically, but legislation that was actually aimed at or directed to keeping black and brown people in a certain place, and that's part of it as well. So we saw a lot of children, young people going to special schools when they didn't need to be there in the 1960s and 70s and possibly earlier and later as well. So the announcement was made, I think, by Amber Rudd, probably 2018 or something like that, after an English gentleman did a series of reports in the Guardian, and an English gentleman reported on a number of injustices, a number of individuals who are not getting access to help or employment, etc., housing. But that wasn't the start of that. And I'm sorry that it took a while for you to get, and I'm not sure it was the transport that caused you later. One of the things that I said at the outset was I've been working in immigration for 30 years, since the 1990s, and I've seen these cases. So it wasn't like all of a sudden we're seeing Jamaican people, Caribbean people, people from the Commonwealth having these problems. They were always having these problems. The entirety of my practice and my colleagues' practices, we never called them Windrush cases. We called them immigration cases or nationality cases of nationality problem. So they were going on long before Amber Rudd's announcement and long before Lily Dennison's. Albeit that it was great that she did all those that important to bring it to the forefront.
Thank you very much. If I could share some light.
Sure.
Because I came to Bermuda. I'm going back on it. I came to England in 1963. I was recruited from Barbados to come to England. And Barbados was one of the only countries where only that you get a job before you get to England. Get the point of it? Okay. I did not know that the 1959 Mental Health Act, which was brought in 4 years before I came to England, was brought in to put me in a mental institution, to send me back to where I was born, and rob me of my British citizenship. I didn't know that. But after I was put in a mental institution in 1977, when I came out, I started to do diligent research on why I was brought to America, why I was brought to England. And as we were brought to England, or encouraged to come to England, to help me build England. But the 1959 Mental Health Act, which came about immediately after in 1958 riots in Notting Hill and Nottingham. Not a coincidence that the 1959 mental health act is relative, because prior to 1959, there was hardly any black people in the mental institution. Why? Because it was considered, it was said that we could not suffer complex mental illness. So how are you going to put it to a mental institution? After the 1959 mental health, what happens in the Jews? Within 10 years, black people represented 25% of the people in the mental institution. My case is in the British High Court, with the British Court for 47 years. So I'm saying we need to look a little bit more at the 1959 mental health act and what happened, what happened in 2018 when the Prime Minister apologized to current heads of government for what she described as the Windrush Generation Scandal. And then in 2019, they introduced the idea of compensation. And we know that the game that has been played, what? But there's a lot more to it.
Okay.
There's a lot more to it because right now, Barbados, this year, started what we call regathering, calling home Barbadians who have lived overseas to tell the story of what happened to them from the 1950s and 60s. So there's a lot more going on.
Thank you. Thank you. I'm just going to go.
There's a question over there. Actually, someone's got.
I was just like, I'm just conscious. I'm looking at this side of the room. I just want to make sure were there any questions on that side? If not, yeah. Okay. Go ahead, sir.
Thanks. This is for the rear tax, with the sense of the disapplication provision of the. I understand that in terms of nationality, which effectively say, as long as you can, or there should be widening so people who will be able to get nationalisation registered nationality. But how does that interact with the local officers which exist to in terms of working out where the liability begins? Because that, for example, facilitates the trigger compensation scheme, which is that it's a liability from here to there. Is there an interaction between what you're asking for in this application and working out what officers?
It will help because a lot of the refusals that happen in the compensation scheme is where the Home Office says that, say for example, you've got a case where someone is applying for compensation because of homeless and documentation to say that they're entitled to benefits so that they could get a home. The Home Office is saying, because you've not been able to produce enough information, balance of probabilities, we don't think you've got a case. Even though they've enacted a law instead that if you haven't got these documents, you can't have this benefit. And you can show them that, well, I didn't have that passport or didn't have that status, but you can't show, yourself rising to a particular local authority or discourse between the local. That documentation isn't there, but the documentation that under the law says, would say, as a balanced probability, if you are told that you're not going to get a certain benefit if you don't have a certain status, then would say that, yeah, on balanced probability, you would have got that. That's ignored. But if we have a situation where that criteria, in that the person
doesn't have to show or prove that, they have to go through all these criteria to get their status back, then I think it would make it easier in terms of their application, that will be used against them getting the benefits that they apply to for compensation. It might be a bit convoluted, the answer, but, there are other cases that, people go through at the moment. There are people trying to get their status back, and the Home Office will say, because you've been out of the country for such a long time, we can't give you status back, and that's because they're applying that status, that criteria, intention to make the UK your home. They can't show that, no matter how many letters they have. They have to own property here and so on and so forth, because that's the criteria that the guidance that the Home Office themselves laid down. So they can't even apply for compensation. But if you disapply those criteria, they could get their status back, and then they could apply for compensation. So what I'm saying is, it's not a silver bullet, because there'll be all sorts of other cases still. But I think that a lot of the cases at the moment, because there are a lot of people in the country at the moment who didn't in limbo, and the Home Office will publish figures as to how many people applied and how many people refused. And it's in the thousands. And we have cases ourselves that, we know that for the last 7 years, they haven't been able to claim benefits, their children haven't been able to go to university. They're just in limbo because they were out of the country for a long time. They're living in the country now, but there's all kinds of criteria and guidance that they have to meet that Home Office laid down, that if we sweep those away, thousands of people who are living here, not talking about people living abroad and having to come here, but living here now, being a drain on the economy, we could be contributing to the economy if we made those changes.
Thank you. I think I'm going to draw a close to this part of the event, but there is an opportunity to continue the conversation. Okay. One more, and then
it's not really a question. I just wanted to. This event's obviously being run as part of a series of events we're running in conjunction with the exhibition in the Grip of Change, the Caribbean and its British diaspora. And so I just wanted to point out, you were talking about the ESM schools. One of the events that we're going to be running is called Education, the Black British Experience Then and Now. And it's on Wednesday, the 26th of March at Senate House. And ironically, because you mentioned Gus John as well, having helped with the deportation, Professor Gus John is going to be here to talk about his involvement in supplementary schools. Macy Barrett, who was a survivor of the ESN school system and is currently taking the government court review day, I believe, for the impact of having gone to an ESN school. She's going to be here as a speaker. We've also got Dr. Cassie Stoll, who's going to be here talking about mental health and well-being of Black students in universities, but also the pipeline issue problems that are occurring. And also one other speaker called Dion Campbell-Mark, who I believe is one of the members of CEA. So just to say that's happening. The other thing that I just wanted to quickly point out is that we've got the Sustainable Development Goals for the UN, and so they're expecting that all countries are now going to be having ID systems put in place, ideally by 2030. So there's all sorts of problems that are going to be reoccurring. And one of the things I just wanted to point out in all of that, because you were somebody was talking about, Professor Audrey, you were talking about paper as technology. I just wanted to point out, as part of the problems we had when we were conducting a project, it was called Windrush Scandal in its transnational Commonwealth context, was that because of the ongoing hostile environment and people being intercepted by immigration officers and all sorts of other people because of the colour of your skin, it makes no difference if you've got a passport or proof that you're British, because people, for example, we've had one person on the project whose passport was actually destroyed by immigration officers because they didn't believe his surname was Chiatow, And then they were like, but you look African. How have you got a Chinese surname? Well, he's from Guyana, and that's perfectly normal in Guyana. But they didn't understand that. And so he then took a 2-year process before he could get his passport back. But also my own case, I've also got a British passport. My father was English, whatever, it doesn't make any difference. I have a British passport. But yet I've had to get lawyers to actually sign an affidavit saying that document is my document. So I don't even understand how we're going to resolve these. And I loved your optimism, Anthony, when you say, well, then, but not so much now. And I just like, yeah, no, not really quite the same level of optimism as you. But I see that as a major problem going forward, in that we're all expected to have ID, but yet still they don't believe the ID that we have.
Yeah,
Now, so it's guilty until proven innocent. You know?
Yeah, let me quickly deal with that, because it's like the Home Office issue when people wanted to run away from Home Office. You've got to look at history rather than say it's about racism. When the abolition of the slave trade was passed in 1807, the same warships that were escorting the slave ships turned their guns when that act was passed on the slave ships and said, you're not going, you're going back to, or stop them, interdicted them. So the same British Navy that was protecting the trade was used to stop the trade.
But that's such a misnomer, if I can say, because it was sent back into slavery in the African country. They were indentured. They weren't even freed when they were sent back.
The point is that the Navy stopped that trade. There were other reasons why they stopped it as well, but it became an instrument of Parliament to enforce Parliament's will. So my point is, let's get to Parliament. Let's get to that. It's not about optimism. It's about looking at what happened in history and saying, if you could have got Parliament to make a decision then about things like that, why on earth can't we do it now? I was saying that in my situation with regards to judicial review, one of the things that I kept on thinking about, but in history, we had people who were supporting the battles for the enslaved people, like, Haiti, which is all over shore. We had Poles fighting with him. I'm thinking, where are the Poles now? And lo and behold, people came forward from D-Day, people came forward from Charles Russell Speechley, and they all started to support. So this idea that it's about optimism and so on, in these different periods of history, you have people ranging on both sides, and I'm saying it's still the case today. You have people ranging on both sides. So let's stop pretending that there aren't people out there who can join forces with us and bring about the change that we want. It's not about optimism, it's about realism, I think.
Thank you. As I said, let's thank our speakers.